Ms. Seymour.
I appear for HMRC, and the respondents are not represented here today. And I believe that your lordships understand the position in that regard. This hearing is to deal with the response of the Court of Justice of the European Union to a reference made by the Court of Appeal on the 19th of March 2019. The request for a preliminary ruling is at tab 6 of the core bundle. And in accordance with the practice direction, the Court of Appeal gave a judgment expressing its preliminary views on the legal question at issue, and these can be found in tab 7. The facts have been fully set out in paragraphs 1 to 49 of that Court of Appeal judgment, and the views of the Court of Appeal I have set out in the skeleton, but they are at 66 to 68 of that judgment. The court considered, however, that in light of the authorities, the position was not clear and referred the questions to the court as set out in its judgment at paragraph 71. Now, the Court of Appeal's views have been vindicated by the Court of Justice, both in the Advocate General's opinion of 21 January 2021 and the judgment of the court. Those are at Core Bundle 4 and Core Bundle 3 respectively. Her Majesty's Commissioners of Revenue and Customs would like the judgment of the 19th of March 2019 by the Court of Appeal effectively to be updated. It may be that your lordships feel either a short supplementary judgment or a pure copy-paste job without the reference bit at the end to save your lordship's time is sufficient. The reason for this is, of course, that there are a large number of follow-on cases, and it's necessary just to have that judgment in an English judgment form. So that's really what my client would like. There is no issue, I believe, between the parties as to the legal principles that apply from the fact that the judgment came after the end of the transition period.
I mean, that's particularly what we'd like you to explore.
Yes, well, I've dealt with it in quite a lot of detail in the skeleton. I'm quite happy to go through those points, and actually it would be quite helpful because I have discovered that the bundle has some errors in it in terms of
I noticed it had the wrong Article 4.
Yes. So I
noticed, though this may not be crucial, doesn't have Lord Justice Newey's judgment in Wilson and McNamara.
No, I haven't dealt with that.
No.
But those principles in effect apply. I have brought, it also doesn't have section 7 in, which is the retained EU law. If I can hand up so you can correct your bundles, I've put the right page numbers at the bottom. So that should go in page 388. I've actually enclosed the first few pages of the agreement. So that would replace the article, the bit about the withdrawal agreement. You can take out the old page 388 and stick that in there. And then section 7, I've put in as 383A.
Just give me at least a moment.
Sorry,
there was one page. There's one page.
There's one page, but
there's now 388.
Yeah, you don't need all those three. It's just the introduction to the agreement.
Okay.
But it takes you through to Article 4.
Yeah.
So perhaps we can start with Article 89,
Of the withdrawal agreement.
86.2 actually, of the withdrawal agreement. That's at page 389. So 86.2 confirms that the Court of Justice had jurisdiction during that transition period.
Yes.
And then Article 89 states that the judgments handed down before the end of the transition period, as well as such judgments and orders handed down after the end of the transition period, crucial words, in proceedings referred to in Articles 86 and 87, that's the one we just saw, shall have binding force in their entirety on the United Kingdom. So certainly at a international law level, they are binding. And then if we go back to Article 4.2, so I suppose we should actually look at Article 4.1 as well. The provisions of this agreement and the provisions of Union law made applicable by this agreement shall produce in respect of the United Kingdom the same legal effects as they produce within the European Union member states. So obviously this judgment has effect.
So sorry, can we just pause there? So
yes.
The provisions of this agreement, so that's including Article 89, shall produce in the United Kingdom the same legal effects as they produce within the Union. So pausing there, under the treaty, we're obliged to ensure that judgments on references have binding force in the United Kingdom.
Yes, and law...
Next sentence too, accordingly. Do you want that?
Yes, accordingly, legal or natural persons shall in particular be able to rely directly on the provisions contained or referred to in this agreement which meet the conditions for direct effect. And then 2, the United Kingdom shall ensure compliance with paragraph 1, including as regards required powers of judicial and administrative authorities to disapply inconsistent or incompatible domestic provisions through domestic primary legislation. I'm going to take you to that domestic primary legislation by which that article was implemented. And so the UK did this in Section 5 of the EU Withdrawal Act, which we've set out in paragraph 18 of our skeleton.
Sorry, when you say Section 5, do you mean the later Withdrawal Act?
Sorry, it's Section 5 of the 2020 Withdrawal Act amended the 2018 Withdrawal Act to insert Section 7A, which you find at page 384 of this bundle.
Yes.
So this was inserted by the 2020 Act. And we see all such rights, powers, liabilities, obligations, and restrictions, that's what we've just seen, from time to time created or arising by or under the withdrawal agreement, and all such remedies and procedures, from time to time provided for or by under the withdrawal agreement, as in accordance with the withdrawal agreement, without further enactment to be given legal effect or used in the United Kingdom. And then the rights, powers, liabilities, obligations, restrictions, remedies, and procedures concerned are to be recognised and available in domestic law and enforced, allowed, and followed accordingly. And then 3, every enactment, including an enactment contained in this Act, is to be read and has effect subject to subsection 2.
So this was inserted in 2020.
Yes, so this is domestic law, giving effect to that international law.
So just pausing there briefly. Subsection 1, as in accordance with the withdrawal agreement, are without further enactment to be given legal effect.
Yes.
Now, if we relate that back to Article 89, or I mean Article 4. Article 4. Article 4.1 says the provisions of the agreement, including Article 89, are to produce the same legal effects, blah, 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 and people are to be able to rely on that. So far, so good.
Yeah.
Then Article 4.2 says that the United Kingdom is to ensure compliance through domestic primary legislation.
Yeah.
So when we come back to Section 7A, subsection 1, and it says, in accordance with the withdrawal agreement, are without further enactment to be given legal effect, is Article 89 one of the things that is without further enactment to be given legal effect? or is it one that does require further enactment because of Article 4.2?
I saw it as I didn't see 4.2 as
You see it as a sort
an
of
obstacle. I didn't see it as an obstacle. I need
belts
to.
and braces.
I need to understand why my lord considers it a. I hadn't appreciated there was a problem. To be quite frank.
What provisions under the agreement are, quotes, without further enactment to be given legal effect? You see. So the this purports to say. I'm sorry if it's not good. Purports to say that under the withdrawal agreement there are provisions coming with A and B that, without further enactment, are to be given legal effect. So what are they?
Well, I thought that was implementing 4, so that was, in a sense.
Is my lord right? It's belt and braces.
I read it as a sort of belt and braces thing, that everything that's in here will be given effect in domestic law.
Why did they need to insert this? Wasn't. I mean, this is. I'm sorry.
I'm afraid I wasn't.
I'm trying to avoid saying this is a chancery point because I don't want to offend the rest of the group. But why do they need to? Sorry. Why is it necessary to insert to pass 7A 1 and 2, given the terms of 4?
Because I suppose in the United Kingdom you have to. In a sense that in the United Kingdom I couldn't turn up in court and rely on this.
There's a sort of an irony here, isn't there, in the sense that Section 7A, you say, is the further enactment.
Yes, because maybe in monist countries this makes sense, but in our constitutional system we still need 7A. I mean, that's the way I would read it, is that I come to you and I rely on Article 4 and you say we don't care what it says, it only has effect on an international plane. And so that's also why there was the commitment
to incorporate
in 2, because it recognised that in the United Kingdom an international agreement doesn't have effect.
So in other words, 2 required the statutory.
Well, 2 is a part of our national law almost. So presumably during the negotiations, the EU, and I say presumably, I have no idea, but presumably they said, well, Article 4.1 is not good enough because anybody who turns up in a domestic court and relies on it will be told that's international law. It doesn't matter what it says. It doesn't apply here until Parliament's made it domestic law.
I mean, so if we go back to 7A1, which is the only bit that sort of causes me trouble, you say, well, looking at Article 4.1, it's perfectly plain that there are obligations here which are, without further enactment, to be given legal effect.
Yes.
So be it. There's 4.2, which is a sort of belt and braces, if there does need to be legal effect. Well,
yes. Yes.
Yeah.
I mean, this is in effect bringing the treaty into domestic law.
The words "are without legal are without further enactment" could be deleted, could have been excluded from 7.1, 7.8.1, and this
well,
because
they could have said with further enactment. It was clearly an international commitment. So the international commitment is without further enactment. bind us, and they will bind the domestic courts at an international level. But we still need to put them into domestic law so that people can actually turn up in court, and that's what 42 is. So I suppose it gave some, if the United Kingdom had not enacted 7A, and we'd been turning up in court and trying to rely on the agreement, and you had said to us you can't, then the United Kingdom would be in breach of the agreement internationally.
Yes. I can quite see if there were nothing like 7A, as you say, when you turned up and said, well, here's the withdrawal agreement.
I mean, is it, I just wonder, without wishing to put any further complication into the picture, is it just 7A is actually just saying that those provisions in the withdrawal agreement, which confer rights, powers, liabilities, obligations, etc., are, without any more specific enactment, to be given legal effect in the UK, because, as you explained, the agreement itself only operates on an international plane. Is the only word that's actually causing a problem is the word "as" at the very beginning of the bit after B? Because if you just read the words in accordance with the withdrawal agreement as being this is what we are doing in accordance with the withdrawal agreement, those provisions have effect in the UK without any further enactment. Don't expect anything else. This is all you're getting. Is it just the word "as" that's causing that little problem?
I confess it didn't cause me any problem, but I can see that perhaps it would have been better not to have "as" there.
Or just "shall," in accordance with the withdrawal agreement, be given legal effect without further enactment.
Yeah, it's basically because. It's
because we promised to do this.
It almost should have been clause 1. Because we promised to do this, we're doing it.
Correct. And it's not that you have to look in the withdrawal agreement for anything that is designed to be in effect without further enactment.
Exactly.
Because that would be entirely inconsistent with what this is actually doing, which I think is what we've been looking at.
So you could strike out "in accordance," and you could say because the withdrawal agreement requires it without further enactment or whatever. But that's in a sense, I think.
And of course, the Supreme Court has recently, last year, spoken, hasn't it, about, reminded us of the importance of incorporation for rights to be in the SC case.
Yes.
So maybe this was
anticipated. Well, I have no doubt that everybody was aware within the EU negotiations that anything that was agreed would have no effect in the domestic courts unless it was enacted through Parliament.
It may just be this is the current style of parliamentary drafting appears to be to sort of break things down into sections which then apply. This seems to be the current vogue of parliamentary drafting. If you'd have actually just condensed it in the way that you've described, it wouldn't actually cause this potential problem.
You don't need the words "without further enactment" at all, at least on your case.
Yeah.
But as you say, well, what this is saying is everything, all rights, whatever, as in accordance with the withdrawal agreement, are to be given legal effect.
And the words "are without further enactment" means just don't expect anything else more specific.
Yes. And it's saying we're not going to enact each and every provision of this vast agreement through different schemas, because of course it covers the vast range of areas.
Yes.
So I expect it was a way of just making sure that they're complying fully with Article 4.
When it says general implementation of remainder of withdrawal agreement, just out of interest,
Sorry, where does it say that, remainder?
That's the title of 7A.
The remainder of withdrawal agreement.
Just out of interest, what is the thing which has already been given effect? To which this is
so I can't give you a certain answer, but I expect it's because some of it was given specific effect, and therefore this is the catch-all. And I have to say that the implementation is fiendishly complicated. I've certainly
Sure.
not. I haven't got my head around all the retained, non-retained. It's very complicated, but I expect it'll be simplified by a few judgments.
And I assume that the Northern Irish Protocol is not part of the withdrawal agreement. It's a protocol, is it?
No, it is part of the agreement. The agreement itself, the international plane, and I can't remember which provision it is, specifically provides that the protocol is part of the agreement.
So 7A applies to the Northern Irish
Well, I
Protocol.
suppose so.
Yes, I see.
Certainly, the withdrawal agreement specifically says it's part of it.
Yes, I see.
So that's the first point, really.
I mean, assuming you're right on that point, that really is the end of it.
It really is the
isn't
end of it.
Because at that point we have a decision of the Court of Justice on a reference in these proceedings, which is determinative in the sense that it shows that the Court of Appeal was right in the first place.
That really is the end of it. I mean, the others are subsidiary points, all set out in my skeleton. But from the revenues perspective, there are 35 cases behind this one. So it's important that they have just an English judgment answering that question. And in a sense, it really isn't a particularly onerous job to do that, because it's just saying that the Court of Appeal got it right, and we're glad that our view was confirmed. And here is the confirmed view.
Sorry, go on.
No, I suspect you're going to ask the same question.
I possibly am. If we approach this on the basis, look, we're persuaded that Section 7A means that we are bound by the Court of Justice decision on the reference in these proceedings, therefore the answer is in your favour. There might then be a further question as to whether that binds in the other cases.
Yes, I'm not sure that it's entirely up to you, of course, but I'm not sure that you need to tackle that.
No.
Anything we said will be obited.
Yes. And that will involve complex questions as to retained EU law, etc. But I think once the revenues concern is that this be put into an English judgment, and that may actually get rid of all the complexity that will arise if people start talking about retained EU law, because as soon as your lordships have ruled on it, then of course it is binding English authority.
Yes, I see.
So unless you want me to, it may be that that's all you need. I can go through the other points, but they are subsidiary points. They don't, and they are set out in my skeleton.
So,
the respondent's position is not really to dissent from any of that. I don't know whether you saw the skeleton.
yes.
It's very lightly put, just raises the question of Section 6.1.
When you say your subsidiary points, you mean Section 6, really?
Yes, I mean the points that I've set out. I think in my skeleton I have 5 points.
If there hadn't been a reference, we would have had Section 6. But you say because
Yes.
there's been a reference, Section 6 doesn't come into it.
Yes. Well, I don't say that. I say that you can use Section 6 as well. Well, yes, I do, because I refer to Section 7A, so in paragraph 21 of my skeleton.
I mean, if you're right about Section 7A, then Section 6 really doesn't matter, because it's not a matter of
Yes.
having regard to the later
Yes.
decision. We are bound by
Exactly.
the later decision.
Exactly. So that is my submission on Section 6.1. And then anyway, we have the point in paragraph 22 of my skeleton that you're in any event entitled to have regard after exit day, insofar as it's relevant. And it's plainly relevant. It's the same case, and it accords with the Court of Appeal's own view.
But as I say, you don't get that far if you're right about Section 7A.
No, that's why these are subsidiary points, essentially. Yes, and same with my second point of paragraph 20. It's a subsidiary point. So if your lordships are satisfied on that main point, you don't need to go to those additional arguments. Otherwise, we say those additional arguments solve the problem anyway, and in any event, enable you to confirm the Court of Appeal's earlier view.
I don't think any of us has any more to ask you, so unless
That's
there's
the
anything else.
shortest, emptiest case I've done in 30 years.
Unless there is anything else you feel the need to draw our attention to.
No,
Then,
thank you very much, and we're very grateful that you'll write this judgment. And thank you.
You said either do a cut and paste job and rewrite the previous judgment with the reference taken out, or a supplemental judgment.
Well, you know what it's like. It's kind of easier sometimes just for there to be a single document, but it's entirely up to you. I do find that when the Supreme Court cross-refers to some other, sub-paragraph of sub-judgment, or you get judgments that refer to judgments within judgments, it can get a bit painful. But it's entirely up to you. A supplementary judgment, if you just want to set out the position on Article 33, may be actually just as useful to any court having to deal with this, because it will be tribunals as well dealing with it. So whatever's useful. The facts may not be of much importance in a sense, because the decision is so absolute as to what Article 33 means.
yes. In which case, thank you very much.
Thank you.